So Gunaseelan, if you just introduce yourself and after that, just take it forward. I'm muting myself. It's your show now.
Yes. Good morning, everybody. I'm Gunaseelan. I'm a trial lawyer for the last 42 years, practicing in the Madras High Court from 1980. Well entrenched in this adversarial litigation process as a trial lawyer. I was glued into the process of mediation when I underwent a training at the Indian Institute of Arbitration and Mediation. And I found that most of the concepts and the practices which are adopted in mediation are akin to what you call a compromise in a legal proceeding. But however, it's a different thing altogether. But if we as advocates could bring about a settlement between the parties, why not at the threshold itself by bringing this mediation process into working? So started focusing more on mediation, and I'd come to realize that mediation as such in India had not taken off as is expected to. And only for the last decade or so, it has seen a growth. In my view, mediation should commence from the grassroots level. The concept of mediation or the practice of mediation cannot be decided by a few sitting in a five-star hotel or in a big seminar hall. And as a matter of policy, it can't be discussed, but it must be approached as to how it could be taken to the grassroots level, that is the end users. To that extent, my endeavor today would be to talk on mediation in the state to which I belong to, the cultural heritage of the state, and the process of mediation, how it could be developed, how it has gained roots, and how we should be taken to the grassroots. That would be my focus. So with these few words of introduction, I think I'll pass the buck to Vikram so that we can commence the session officially.
No, you can start, Gunaseelan. I think you can just take your presentation through.
Yeah, fine.
I'm out of the picture.
You see, this mediation is a concept which was not as conceived now that was existed earlier. Today, we understand mediation to be a negotiated settlement arrived at between disputants, facilitated by a third-party neutral. So normally, that would mean a negotiation at the first instance. There are a lot of scientific theories and a lot of definitions of how to go about doing negotiation, and the structured process which mediation offers, if utilized in the proper context by the third-party neutral, namely the mediator, the process could be a successful one. Basically, we should understand one thing. Society as such is a composite of individuals. Individuals have no hesitation in talking with each other. And conflicts is part and parcel of a society. Be it a conflict between communities, be it a conflict between societies, be it a conflict between nations, or be it a conflict between individuals, conflict is an integral part of the society. Conflict is not a bad at all. It has got its silver linings also. In the sense, at the end of the conflict, you reach a position where you have realized something or you have learned something. And how far to take it up is, of course, obviously in the individual hands. Now, speaking of Tamil Nadu, as everybody else would have spoken, and is everybody mediator, in everyone who's well aware of the subject of mediation, as an alternate legal process, dispute resolution mechanism, will always refer back to the panchayats. Now, that is the starting point for any talk on mediation, where the communities decide where the communities meet together and resolve a dispute between individuals in the communities or between the communities. Of course, obviously, the decision there is taken by the community elders, unlike mediation, where the decision is taken by the disputants themselves. Now, everyone is aware of the fact that even United Nations has recognized the fact that one of the oldest languages prevalent today is Tamil language. Tamil Nadu, as such, has got a rich cultural heritage, and it goes back to its language. Normally, the cultural compact of the society is determined by the literature that flows from the community. The Tamil cultural heritage could be linked to the Tamil literature, which is between, I would say, CE, for example, BCE 6th century to 3rd century CEC now. So this period of is known as the Sangam period in Tamil culture. The Sangam has got three different facets. There are three different Sangams. The last Sangam period is was the one which is known as Muram Sankarabhuvam. There are a lot of meanings to that. Let me not go into it. Now, the 600 BCE to 300 CE is the Sangam period. And if you look at the Tamil literature, the map of India, the Sangam period would be shown as inclusive of the old Tamilagam, that is what they call it as, spoken by language. Now, it is correspondingly roughly to the most part of the southern India, consisting of territories present today, namely state of Tamil Nadu, Kerala, parts of Andhra Pradesh, parts of Karnataka, and northern Sri Lanka. This is known as the Elam period. Now, the Sangam literature as such is a very interesting aspect. You see, they have three. Tolkappiyam is the first Sangam literature, which has about 1,700 poets written that. The author of that epic is known as Tolkappiyar. It is a literature. And this was developed mostly during the Pandya period. You see, there are three predominant kingdoms, Cheras, Cholas, and Pandyas. Now, this Tamil literature, Tolkappiyam, is the grammatical work. And there are 8 anthologies of the poetic works known as Yettu Togai. Yettu means 8. There are 18 minor works known as Padinan Keel Kanakku. So there are 5 grand epics consisting of Manimegalai, Sivaga Sindhamani, Silapadigaram, Valayapadi, and Kundalakesi. These are the major epics, and a few lesser epics, 5, known as Nilakesi, Naga Kumara Kavyam, Udaya Kumara Kavyam, Yasoda Kavyam, and Sudamani, combinedly known as Ainchiru Kapiyangal. So, the entire Tamil literature, as depicted in these literary works, reflects the entire community of Tamils as such, originating way back into 600 BC. That's how we call it as. Now, you see, this Tamil community originally as such had only called groups of people. There are, for example, I will give you this. They are known as, let's see, the village is the common factor. And the village is the bottom in the hierarchy. Above this village, there are mandalams, that's what they call it as. 9 villages composed together, or 8 villages composed together, as known as mandalams. And then comes the fiefdoms and their kingdoms. So the emperor is the ultimate authority, the ultimate justice dispensing authority. And below him, the most commonly deciding authority on disputes is the villages. And this village consists of the village elders. Now you would know that in Tamil Nadu, initially the landscape was divided into 5 different sectors. That is, they call it as the what do you call it? Sandy soil, rich agricultural soil, then hill stations, water bodies. So people who are scattered and who are living in all these areas have developed a culture of their own, a vocation of their own. So mostly the community is composite of workers belonging to that particular area, utilizing for their livelihood that income which they derive from earning from that particular region, namely trades connected to that region. So craftsmen, tradesmen, and then the artisans, they compose the majority. Apart from this, they had this, every king has got a huge army, cavalries, then the trading community. And therefore, there was more of a division of the community by the trade they professed in, and not by virtue of the caste they belonged to. The caste system came later on, right? Later on in the Tamil culture as such. Now, as the society grew, disputes grew, you see the kingdom, the king as such, dealt with high espionage cases which were known as offenses against the kingdom. And all other offenses, adultery, bigamy, theft, murder, arson, looting, everything else. Everything was decided by the local village community. That is how the system worked there. With this panchayat system is very unique in the sense the panchayat is headed by the village elders, men who are respected in the community, in the villages, and they are chosen. You see, they are chosen by the king to be the head of the villages. And they are also supposed to be the judges, men of high caliber, men with high integrity, men who commanded respect in the society. So people felt no grievance in going to the village panchayat for a resolution of their disputes. That both sides are heard, both the viewpoints are taken into consideration, the community's requirements are also taken into consideration, because the cohesion of a community must be maintained. To that extent, they tried to find a solution which is acceptable for the parties. In the even mostly 99%, the villagers, that is the disputants, abide by the decision taken by the village elders. However, there are a few instances where the disputants themselves may not accept the decision of the community, and then they are outcast. That means they are cast away from the village, and nobody is allowed to interact with them in any manner whatsoever. Sharing of crops, getting of labor, food, water, everything. They are cut off from the village as such. And in other heinous crimes like theft and other things, of course, retributive justice is meted out. So this was the system that was prevalent very much. Then when the East Indian Company came into Tamil Nadu, that is Fort St. George, then they introduced their system of justice, which is adversarial in nature. They had a judge, they had a person who decide this, and then obviously the court system, litigation system came into vogue. I would like to highlight one Privy Council decision in this aspect, because as I've been saying, the village communities are the best, have adopted the best standards of meting of justice. That's ultimately the purpose. You see, today we talk of Nyaya, Nidhi, and all that laws, rules, and regulations, and this entire mediation syllabus, which today, as we call it, is based on the English concept of natural justice, positive justice, schools of jurisprudence. They come into play while you determine what the mediation basics are. Nyaya Nidhi, as expounded by our MCPC, or as is known in India now, I wouldn't say MCPC, but mostly the distinction between Nyaya and Nidhi found the essence of the basics of building the process of mediation. You see, in 1934, the Privy Council had come across a case in the earlier system. I'm talking of the system where the village elders sat together and resolved the disputes between the parties. Now, this particular dispute ultimately ended up in court. But of course, I'm talking in terms of 1930s, after the advent of the British. See, that had this is a huge properties was involved, and it was a family dispute between two sisters. One sister who had no wards of their own, the other sister with lots of children. Ultimately, division of properties came into vogue, and that division of properties was done by the village panchayat. But after about 50 years or so, they continued, and alienations were sought to be made by the successors who had inherited certain portions of the properties under the division of properties made by the village panchayat. Now, the Privy Council, when it applied its mind to the facts of the case, assessed the manner in which the village community came to divide the properties. And this is what they have got to say. I'll read it out for you. Reference to a village panchayat. If anybody wants a citation on this, I'll give you the citation straight away. You can make a note of it. 1934, 36 Bombay Law Reports, page 563. The decision is of the year 1934. It is made in Vitla Sitana versus Marivada Viranna. Here, in para 12, the Privy Council says this. A reference to a village panchayat is a time-honored method of deciding disputes of this kind and has these advantages. That is, it is generally comparatively easy for the panchayatdars to ascertain the true facts. The first element. And that, as in this case, it avoids protracted litigation, which, as observed by one of the witnesses, might have proved ruinous to the estate. Looking at the evidence as a whole, Their Lordship sees no reason for doubting that the award was a fair and honest settlement of a doubtful claim based both on legal and moral grounds, and are therefore of opinion that there are no grounds for interfering with. See the sanctity which this Privy Council placed on the village panchayat, which is a time-honored method of deciding disputes here in India. This case arose in a village in Tamil Nadu, of course. Then, of course, the King's Council sat in Bombay, therefore the matter went up to, and it is reported in the Bombay law reports. What we speak today of mediation, what we speak of the advantages of the mediation, namely an easy method of ascertaining facts, avoiding protracted litigation, and a fair and honest settlement. This is what mediation is aimed at. Now, with this cultural background, we should realize one thing. The people here have in their blood, right from the what we call as Stone Age, a method for resolving disputes. That method was a community get together and ascertaining the facts and ruling upon and putting out the possibilities that this would be a viable settlement for you people to live with. And that system is ingrained in the culture of every society. I am laying emphasis on the Tamil society, but this is ingrained in our culture. Let us take this further. Now, you see, mediation, this was loosely termed by the Privy Council and other judicial systems as one form of arbitration. Arbitration necessarily because the decision was taken by somebody else. But then conciliation. Again, somebody is there to rule over it. But in mediation, it is a facilitative process. No decision is taken by the mediator. Therefore, mediation process is very unique in itself. Now, with the Indian courts taking up all and sundry cases, you see, nobody can prevent a person resorting to court of law. And under Section 9 of the Code of Civil Procedure, as it stands today, as it stood today, as it stood then, encompasses all disputes. Now, of course, specialized legislations have come where specialized mechanisms have been, statutes have come into force, where a system is created whereby disputes are resolved through that forum. Disputes are litigated through that forum. I'm sorry. So now, the adversarial system, what had happened was, had fueled the need to maintain that ego that person holds on, that he is right and he has to win. See, the adversarial system brought about a win or lose situation, whereas the earlier Panchayat system brought about a collaborative solution to a problem. With the multiplication of litigations and with the dockets exploding in the courts were not able to deal with this explosion of dockets. And so necessarily they have to find out methods of easing their work. Of course, building up the infrastructure of courts is something different, that which the state machinery does. But how long you can keep on building infrastructure after infrastructure? How long do you think you can keep on increasing the number of judges and meeting out their expenditures? So the courts felt that there is a necessity for alternate mechanism for dispute resolution. That is how arbitration came into vogue. That is how conciliation came into vogue. Fortunately for us, in our Chief Justice, Justice Ahmadi, whom we must give credit to, see, way back, he brought a team from US. That was in the year 1994-95. The Indian Supreme Court, they initiated an Indo-US exchange of information between high-ranking members of the judiciary. As a part of this effort, former Supreme Court Judge, Chief Justice Ahmadi, met with US Supreme Court Justices Ruth Bader Ginsburg and Antonin Scalia. And this gave room in the year 1996 for bringing about Section 89 into the Code of Civil Procedure. For the first time, statutory recognition was given to the alternate dispute resolution mechanism known as either Lok Adalat, conciliation, or mediation. That was brought into the Code of Civil Procedure thanks to our Chief Justice Ahmadi way back in 1994. By then, the world has grown large. You see, in United States or in Britain and other European countries, mediation was not a difficult process for the people to observe. They preferred it. However, in India, this took a long time, because by that time, the Arbitration Act also had come into force. So arbitration had provided a viable alternate to reduce the docket explosion in courts, and arbitration system flourished. It flourished so much so that it has got now a well-established, structured system with a definitive conclusion. Now, obviously, of course, the appeal provisions are there. But the business community as a whole prefer to have arbitration as an outlet for resolution of the disputes. Mediation took a back seat. Then this Legal Services Authorities Act came into force, Lok Adalats came into vogue. And I must be very frank here when we speak about the alternate dispute resolution mechanism. When we speak of alternate dispute resolution mechanism, what strikes in our mind today straight away is Lok Adalat, arbitration, Lok Adalat, conciliation, mediation. This is how it is spoken of. Now, when the state took over the structuring of this alternate mechanism, dispute resolution mechanism, now the Legal Services Authority and National Legal Services Authority Act and State Legal Services Authority Act came to play. And as any governmental organization, they have to show statistics for the amount of money which is being spent. And I would say, as I have been witness to that, and as I have seen it, that today you can take it from me, 80% of the cases that are settled in Lok Adalat are cases that are already settled and compromised between the parties before a court of law. And then the court of law says, instead of we incorporating and giving you as a consent decree, why don't you go before the Lok Adalat and get an award, which is equivalent to that of a decree. So what happened, the very courts which opted for an alternate dispute resolution mechanism started promoting this alternate dispute resolution mechanism to suit its convenience. And therefore were equal participants in the process. Then what happened? People did not go to Lok Adalat directly. They came to the court, decided the matter, then went to the Lok Adalat and got an award. Now that is what is happening. Now with mediation, the court said, all right, now this arbitration is again seems to be flooded with all sorts of appeals arising under. The Act requires some modification and some amendments and all that. I'm speaking in general terms, but this is the point. So what happened? The arbitration as such, even though it is well structured, governed by well-established principles, is still a decision made by a judge, the arbitrator. The parties have got only a say in appointment of the arbitrator and the rules to which the arbitral proceeding shall apply. To that extent, the parties have a say. Beyond that, no. The same system of evidence, the same system of submissions. So what happens is, what the litigation process suffered with the arbitration is also now suffering. In addition thereto, the arbitral process initially, of course, no time limit was fixed for arbitral proceedings. Now, of course, 18 months statutory period has been brought into force. But to say a few of the eminent judges, whom I wouldn't like to name, but they're very clear that today arbitration is an area where it has become a retired judges mafia group. I'm sorry if I have to use this word, but that's a fact. Most of the arbitrators are from the community of retired judges who find another occasion, and fees are exorbitant. Now the corporates and other people, commercial establishments which have gone in for this arbitration are now frustrated. And what happens here? It is hugely expensive, time consuming, and for each and every issue where there is a difference, they always go on an appeal before the court, And once you remember, once it goes to the court, it gets stuck in the court. Let me tell you from my 42 years of experience as an advocate, many cases, be it commercial, be it personal, be it family, be it proprietary cases, be it a contractual case, it could be easily done, resolved, even at the initial stages itself. Somehow, in the wisdom of our judges, the wisdom of the judiciary, they thought we will incorporate it within our legal system. That is how mediation is brought within the alternate dispute resolution mechanism. In my view, as a mediator and who has seen the value it creates in the society and among individuals, among disputants, you have to remove this mediation from the alternate dispute resolution mechanism as a whole. You can no more club mediation as an ADR process. You should remove it from the ADR process and let the mediation process grow. You see, when the courts started mediation centers, starting from Madras High Court and then Calcutta High Court, and invariably now every district has got a mediation and conciliation center. Even the litigations, the pending litigations are referred to mediations through these court annexed mediation centers. The net result is a success rate of only 10 to 11%. The reason being, first and foremost, the parties are forced into a system. You see, people who have been fighting in courts, who are deep rooted in that litigation by then, if you are asked them to go to mediation and resolve it, how would they come forward to do it? So it requires enormous amount of caliber in the hands of the mediator to convince the parties, yes, this is the viable system where you can resolve your dispute. Why waste money or hair on the court? As I said, Privy Consolidation way back in 1934 pointed that out while referring to the village panchayat system. So, in the court annexed mediation system, one, the net result is failure. The dispute doesn't get resolved. 11% of the disputes get resolved is because of one, the ability of the mediator to convince the parties that resolution, that is settlement, would be the best way out of them to get out of this. Because by then, even now, there is a saying in English, I would put it like this. A person who goes to the court and who wins the case sits in the room and cries. The person who loses the case sits in the street and cries. Nobody is the beneficiary here. So when a win-win situation process is offered to them, the immediate answer would be with us all, yes, come on, let us go ahead and take it. But it is not so. Why it is not so? It is because people do not know what mediation is. The litigants do not know what mediation is. The lawyer community are not fully convinced of how the mediation system works. As Andrew Miller, one of the eminent who got this 2021 year award for the best mediator globally, he would refer to the lawyer community as the good, the bad, and the ugly. Because the good lawyers would say, come along here, this is a matter where we can iron out the differences and settle the matter. Bad would say, now could it be done? The ugly would say straight away, no. because their pockets are their criteria. How much money is involved? Now, that brings me to the next portion of my topic, which I think will be the concluding portion also. How do we grow from here? How do we go from here? I've been telling you, the courts have been promoting this mediation system. It is the courts that had created the court annexed mediation centers. It is the judges who are, and now the judge mediator system is also coming into practice. But these are all not going to help unless and until the end user, that is the person who's the beneficiary of the mediation system, understands what this mediation process is all about. You and I may understand. We knew the benefits of it. But does the common man understand? My answer is emphatic no. I'll tell you from my experience. After I took up mediation as a serious subject for practice, when disputes started coming to me, when clients started coming to me, I've grown in this legal profession. By now, I don't entertain clients by myself. Most of my juniors handle the matters. But when the juniors bring the briefs to me, I ask the clients to come. Then I ask them, look, why don't you sit and talk it out and finish it off? This is a matter that can be easily solved. Who is representing the other side? Shall we call them and do it? They're very reluctant. They are afraid. They don't want, because they'll say, what if it fails? Where do we go? Why do we spend time on this? But how am I to convince them? No, it will not fail. We can always have a win-win situation here. But parties are very reluctant because they do not know. And they are afraid to venture into uncharted territory. I would say mediation today remains as an uncharted territory. So my understanding, my grasp of the whole process of mediation, and in theory is very sound, but in its application, I find that it has not been applied in a manner it should have been. I would not blame any institution for that, but I would rather blame the persons who propagate mediation as a viable process for that, for they are not taking any effort to take this mediation process to the grassroots level. How could that be done? There are very many ways of doing it today. There are a lot of hindrances, there are a lot of obstacles to that. But you don't remove the process merely because the obstacles are there, you remove the obstacles. The obstacles is public awareness. So what I would suggest is mediation should commence at the earliest stage itself in a person's life. The best place to start would be a school. See, in a school, there are parents, there are teachers, there are students. Every school has invariably parent-teachers association. And invariably, in every school, where there are students, there are frictions, conflicts. Every day that you see fights take place in schools. As I have seen in certain Western countries, and I have seen in some expert mediators who have now taken to specializing in area of children's mediation, they have openly welcomed this move. Make mediation one of the activities that is an extracurricular activity in a school. Form a mediation club. Have some of the experienced teachers, teaching staff, faculty, with experience grows wisdom. With wisdom comes, yes, there is a possible solution for an amicable settlement. Train them, inculcate in them the basic methodology of conducting mediations. Start from the schools. Now go to colleges. There is a very common concept that is taking place, peer mediation, that is what we call it as. Go to colleges. They have National Services Authority, Society, NSS. They have so many voluntary bodies there. They have so many voluntary associations are there. I'm talking of arts and science colleges. Let them have a mediation club. And professional institutions like schools of management, where tomorrow's business leaders are built. There, make it a part of their curriculum. Chief Justice Bobde said when he was in office, mediation must be made as a compulsory subject for all the law students. And fortunately for us, the Bar Council of India had made mediation now as a compulsory subject for law graduation. Now they have framed a syllabus spanning into, say, 6 different areas and of 6 different semesters. It deals with every aspect. Because I've seen the syllabus. Syllabus is good. The problem is when the national law universities were started in India, the students were trained to be highly adversarial in their skills. Therefore, they brought in this moot court system into existence. Moot court system taught the lawyers the way to argue a case, the way to prepare a brief, the way to present a case before a court in an adversarial setup. And you know what? They were given credits for that in their school, in their rankings, school rankings, college rankings. But when I noticed the curriculum of the mediation, and when I compared it with the grading system, apparently no credits were given to students who pursue mediation, except for the regular marks they get in the subjects. So how would this grow? You see, everybody who comes to know of mediation in the first initial stages are so excited about this mediation process. But a sustained interest in mediation cannot be maintained because of the infrastructural defects which we have. We have to cure these infrastructural defects. So my suggestion would be schools, colleges, law colleges, and professional colleges, where this mediation could be introduced initially as an extracurricular activity, blended into a curriculum activity, and linked with their grading system, their performance related to. Today we have colleges in and around which where everybody carries on social service activities. They can take up the mediation process as an alternate to the adversarial system of jurisprudence to the people and explain to them about that. You are having so many legal awareness camps. How many mediation awareness camps are being conducted by the National Legal Services Authority or the State Legal Services Authority? Now, the MCPC is more interested in bringing this mediation to the knowledge of the judges, and the lawyers. But what steps it had taken to take this to the people? It must not only merely form a mediation and conciliation center, but it must imbibe in this mediation conciliation center a duty to go to the masses, like the legal awareness societies are taking place. Nothing comes cheaper, nothing comes easier, and nothing comes free. So that brings me to the next aspect of mediation. Mediation as a luring area of practice for lawyers who are already in mediation, the fee structure must be changed. See, the amount of money a litigant or a disputant is going to spend in a litigation process or in an arbitral process as compared to the mediation process is very minimal. Now, that minimum is not an incentive for any lawyer to take this up as a profession by itself, as a branch of profession to be practiced by itself. So there must be an incentive. There must be a fee structure which must be lucrative enough for lawyers to go into this kind of practice for mediation practices and for mediators also. Next is, let us not muddle the field of mediation. The most, what I would say, the fearful thing which I'm offering right now is mediation as a process here now has been forced upon us, that is forced upon the litigants, the litigating public, the judges, and the lawyers by the courts, by the judiciary, and they're trying to develop it. What happens now? They emphasize so much on this mediation process, thinking that they are furthering the mediation process by putting in various provisions in the existing enactments to offer mediation. More particularly, I would say, the Commercial Courts Act, with pre-litigation mediation as a mandatory requirement. How many have done that? They give an exemption clause. In matters of urgency, you can always go before the court. This 2018 amendment came at a time when pandemic also showed its ugly face in the society. We are now in 2021, and in 2018 end till this 2020, we are all going on a virtual mode with a few differences here and there about the physical mode of hearing. Invariably, in all these cases, for the last 1.5 to 2 years, there is no pre-litigation commercial mediation. Mandatory requirement that has been given a go-by. Now you see, we have Company Codes, 2013 Companies Act bringing in a mediation as a method of resolution. We have Consumer Protection Act. We have Negotiable Instruments Act. We have now made the Family Courts Act, the Marriages Act. I can roll out a stream of legislations, say maximum 20. The provisions are inserted at the instance of judges who wanted, come on, go ahead and do this. And now what they have done? Now they have done is to form a committee to draft a mediation law, saying that, look, we should have a mediation act which should regulate this process. And therefore, and that will make a huge progress, a leap forward. And it will, what do you call, in today's economy, it will make the ease of doing business in India more popular. I doubt so. When the Arbitration Act itself had not made ease of business doing in India, how do you think mediation is going to? By bringing about a separate legislation for mediation. Secondly, you must remember the Singapore Convention, as we normally call it as, has made the enforcement of negotiated settlement agreements arrived at between the disputants in a mediation process as enforceable among the member signatory countries. And now the ratification has been done also. In 2018 it came, now it is in vogue. But like there is a treaty bar for under the arbitration regime, mediation, there is a legislation bar according to the Indian legal experts, mediation experts. They all feel, yeah, we should have. At best, I would say, if at all, if you are going to bring in a mediation act, see, mediation is a process that is a voluntary process. You cannot compel a party to go for a mediation. And the Mediation Act at best can give a legal recognition for the mediation process. It can, at best, and it should, legitimize the role of a mediator and should fix the guidelines and the standards of accrediting a mediator. And it should also govern the rules of ethics in respect of the conduct of mediation proceedings and that of the mediator. These are the ambit scope within which probably a mediation act may do its best job. Otherwise, mediation as such, if it is brought about by a litigation, may not serve its ultimate purpose. You have seen how the insolvency banking code, insolvency code has now come into vogue, and how many litigations are there interpreting the very provisions of that. I am equally sure tomorrow, if this Indian Mediation Act comes into force, there will be as many number of litigations interpreting, attempting the courts, asking the courts to interpret these provisions in a manner which these parties want to. By whom this act is to be framed? Is the legislative body doing it? Now, this act has been drafted based on the recommendation made by the Supreme Court committee. The committee was formed by the Supreme Court. If I look at it, I look at this committee as none but all those institutions that today profess that they are advancing mediation as an alternate dispute resolution mechanism. Now you must remember, the Singapore Convention has ruled out all mediations outside commercial mediation. So Singapore Convention is confined only to commercial disputes. Now the Singapore Convention also emphatically rules out any negotiated settlement agreement arrived at using the court process. So today everybody is saying, oh, the Singapore Convention has come now. Enforceability of a negotiated settlement agreement may not stand as a big hindrance. It is a stepping stone necessarily, no doubt about that. It is a good stepping stone for further development of international commercial mediation. But it is just a beginning. If you bring about Mediation Act here, why these mediation institutions alone are the persons who are drafting and recommending it to as a mediation legislation? Fortunately, it has still not come before the legislative committee. There we can discuss the pros and cons of various provisions, where we'll have sufficient opportunity of public hearing on that. Then all these opinions could be had. The pros and cons of having a mediation act could be discussed over there. But I would emphatically say the mediation process must be taken out of the alternate dispute resolution mechanism. It must be used as a mechanism to stem the dispute at the initial level itself. Before a dispute escalates and takes its route either via arbitration or through a judicial process, mediation must be there to stem the flow into the other systems. So in my opinion, mediation must be the primary dispute resolution mechanism. The arbitration, litigation, and all other systems you are talking must be alternate dispute resolution mechanism. If we build and our structure, the mediation structure, on this basis, I see a hope, a light at the end of the tunnel. The tunnel which we are now crossing through is really dark. Mediation as a process is an immensely spiritual, beautiful process. It is a process, if applied properly and efficiently, with all the necessary ingredients attached to the very process of mediation, it will be a huge success. Only if the end users are aware of it. I was talking of schools, I was talking of colleges, I was talking of law universities, law schools, I was talking of management schools, I'm talking of professional schools. I would go one step further and say, let us take it to the communities. Now, how are we going to take it to the communities? There are two qualifications attached to this community mediation. India, you must accept, in Tamil Nadu as we accept, in India, you must accept, is a country divided by languages and by castes. To break this caste system and to make the people come and sit before a mediation, unless and until the communities are educated about social justice and how mediation can bring about social justice, it will be a very difficult job. Because in a mediation table, the parties should be equally placed. There can be no inequality so that one can dominate over the other or one can pressurize the other by means not visible, especially caste communities. So I would suggest each and every educational institution that has got a community nearby, village community. There are a lot of villages. Take it to the villages, gain the confidence of the elders of the communities there. Gain the confidence of the elders of the community. Make them part of the literacy program. Through them, you spread the awareness about mediation as a viable solution. Next, this I'm talking of communities on a village level basis. In urban centers, it will be very difficult because urban society is a huge society. But fortunately, we have housing societies, we have residential area societies now. Every area has got a residential welfare association. Why these associations are formed? To gain better access to the benefits from the governments, municipalities, electricity board, highways department, to get benefit for the communities. Take it to this residents welfare association. You can also have mediation among your residents who are litigating, either litigating or about to enter into litigation process. We can have community mediation through these residential welfare associations. And today you can see in any urban cities, multi-number of high-rise constructions, housing nothing less than 4,000 to 5,000 families in a single, in a gated community. Go to this gated community working committee members, president, secretary, and committees. Now the Apartment Ownership Act has come into vogue, and it has got its own executive committee. Talk to them. Ask them to incorporate this mediation as one of their society's registration rules, society's rules, and make them realize. What I'm saying is it takes continuous interaction. Everything is not got in a single day. So the future is open to us. As I said earlier, we are traveling through a dark tunnel. There is light at the end of the tunnel. Let us reach that light faster. I must appreciate Vikram on this. I have not heard Vikram before 1.5 years back. So the ideas which he was putting forth were ideas that were brewing in my mind way back in 1918 when I went through this mediation training program. So I found an affinity with Vikram, and these are ideas that are workable. They are workable. Now Vikram is taking it on a level which I could not take it sitting inside my room among the global leaders in mediation. And you see this lecture, I'm the 36th speaker. We have got another, I think more about 40 speakers or so coming up. Every one of them will come up with something new to speak about this culture of mediation. Culture of mediation, which Vikram speaking of, is ingrained in every society. Undoubtedly about that. The nonsense of NAU, NINCs, the nonsense of how you take this mediation culture to the end user. You always think about mediation process as not as a self-serving process for you to be a highly acclaimed mediator or to be an income resource building occupation, specializing in the field of mediation and negotiation. Yes, no doubt you can do that. Yes, we are professionals, we are bound to do that. We got to earn our bread. Nevertheless, we have got something larger at stake. Something larger at stake. What is that larger at stake is a systemic transformation is what we are aiming for. The systemic transformation shall and could take place only through taking this mediation as a culture to the end users so that the future generations shall not wrangle any of their disputes, spending time and money in courts or before arbitrators or before anybody else, or as is now commonly resorted to, armed thugs who are entering into this arena of mediation, say, we will solve a problem for you, otherwise we will use force. Now we have got it in our own system. We have everything with us. We have everything before us. All it requires is how we use it to gain the ultimate, namely a society that is culturally oriented towards mediation, a transition society. Let us aim for this systemic transformation. Thank you. Thank you all for listening. Listen to. Thank you, Vikram, for having given me this platform to speak about mediation.
Thank you, Gunaseelan. That was an excellent presentation. A lot of things you covered there. The only thing that comes into mind is that the fact that you spoke about the village system, the panchayat system, the decision aspect of it. Now we keep talking about spreading a culture of mediation. If even at the village level, people do not think they can take the decision on their own and they need some other body to do it, then how do we tell them that mediation is something that they can use, that whole collaborative method of resolving disputes? Where do we put it in their system? How do they know what it is all about?
Yes, exactly. What is the legal service authority are doing? What are the legal service authority are doing now today? They are conducting legal awareness camp. You take it to the local schools. That is where I'm saying you have to have the support of the village elders, the local schools, the local elders who are respected in the communities. And through them, you take this mediation. Maybe they are reluctant at first to accept the fact that somebody else can decide, why should I be there? Why should I be the village head? Why should I be there doing this job?
Yeah, because
But then,
please.
once when it is brought to their knowledge, yes, they can make a decision. You see, in Tamil we have a proverb, like, சாட்சிக்காரன் காலில் விழுறதை விட சண்டை போடுறான் காலில் விழுந்தார். அதாவது when you can fall at the feet of the witness, you need not fall at the feet of the witness. Rather go fall at the feet of the opponent. You may get a result.
But is there any example of actual mediation in Tamil culture? At any stage, at village level or otherwise, any example that we have where mediation has taken place? So basically, I circulated the theme when I said the definition of the Singapore Convention that the person should not have the authority to impose a decision. So do we have any such example? Because how I'm looking at it is that will at the village level, the panchayat, or in the schools, the principal, the teachers, are they willing to let go and say, look, you can do it yourself. You don't need us. Are we creating that atmosphere? Will they create that atmosphere?
Okay, Vikram, that's a direct question. My direct answer is no. You have not. You don't have, to the best of my knowledge, a single system where the parties by themselves have come to the conclusion. See, at best I can say, in my experience, I've come, let me give a small brief background about my upbringing. You see, I was born in a village. I was born in Sri Lanka way back in 1956. When my father's great-grandfather was the Kankan, he's the one who used to take the laborers from Tamil Nadu down to work in the tea estates there. I was born in the year 1956 March. 6 months, I think in September or October, my father decided to shift to India under the Simavo Bandaranaike Nehru Pact, where we were allowed to bring, including the household furniture, along with us without any customs and everything. But when my father came to India in 1956, we went straight to our village. I did my first standard in my local village. Then my father said, okay, we have got some, we can buy some better agricultural land somewhere down. And we did have our own farm. Then he bought some more agricultural lands, shifted over to the next about another village, about 40 kilometers away. Therefore, I had to do my second standard in a different school. Then third standard, my father said, okay, fine, I'm going to set up a store. He did set up one. And if I had to come back to teach again to do my third standard in a different school. Now, fourth standard, fifth standard, then my father decided for the children's education, the best way is to shift to a metro city. We had two options before, either to go to Bombay or to Madras. My father chose Madras, as it is close to his own native place and my mother's own native place. And my formal education in a regular school actually started my fourth and fifth standard, not even that, from my sixth standard onwards. Till sixth standard, I was studying my mother tongue, Tamil. When I was doing well, my headmaster came and told me one day, you fellow, you're really doing very well in your exams. Better start going to English medium. See, in those days, I'm talking in terms of 1969, 70, 68, 67. English medium is supposed to be high medium. He said, I'm shifting you to English medium. On seventh standard, I started studying in English medium. I had a huge problem. I can never understand the language. I can never speak in English. I can never, compose a sentence in English. How do you expect me to study science, mathematics, physics, geography, and everything in English? My scores are 3, 2, 4 like that. Then one day the headmaster called me and told me, he's a reverend father, of course. He is now, I think he must be around 85 or so. He's still in Nigeria working among NGOs. Now, what he told me was, Gunaseelan, for you to study the language, for you to understand English, better start thinking in English. And then he was the one who made me really grasp the idea of how to master the language. He said, start reading books, Enid Blyton stories, comics, English comics, and start thinking like those characters. You start thinking. Before even you utter a word, start thinking in English. So as the time grew, I had absolutely no problem. When I entered Loyola, I was far above many students who were speaking English by standards which they then called as an English-speaking talent. Now, what I'm now trying to tell you is this. In all these villages where I lived, where I used to go back for vacations, mostly summer vacations and Pongal vacations, that is when the harvest festival takes place, I have seen with my own eyes group of people sitting under the tree and talking over issues. We used to stand by the side with either a sugarcane hands or something, chewing it off and see what's happening there. People talk animatedly. And then I have seen both the disputants agree on something, and then the village, okay, yes, now that you people have agreed, let that be the answer. So what I'm now trying to emphasize, Vikram, is indirect answer to you is, have the parties resolved by mediation the dispute themselves? No. But has the panchayat system enabled them to resolve the dispute by themselves? Answer is yes.
Okay, so but basically what you're saying is that there is in the panchayat system a point up till which they are encouraged to settle the disputes within themselves, and if they can't, then a decision is passed. So
mostly when
so basically it's a negotiation arbitration situation, or do they actually get involved in the process and actually
They
facilitate the
get
process?
involved in the process. You see, the problem is this. You see, today's mediation, when we talk of, excuse me, see the one-to-one system here today in today's mediation, when we sit, we make only the disputants sit. Why? We do not want the disputants to be prejudiced by what the others are going to say. But you may not realize that ultimately the decision makers are outside the table, might not necessarily be the disputants. But there in the village panchayat system, what the benefit they had was the viewpoints of everybody associated with the family were there. They were giving their feedbacks. Then the parties who are at dispute were able to determine, okay, this would be the best method. Okay, now that he is coming forward this much, I will go this much. So that is how negotiations. That's as you rightly pointed out. Up till certain stage, negotiations do take place, and in many cases, that an agreement is reached, which is then converted into form of a decision by the community elders.
Because
As
how
it happens today in a litigation, the parties and advocates sit together, talk, and then they come into a compromise. A compromise memo is filed, and parties come to the court and they say, yes, compromise memo is there, matter is over. A decree is passed.
no, because the way I'm looking at it is that one end we have, of course, the colonial point of time, that kind of a mindset that the British would have got in, and the fact that these are the people who run it, they will take a decision for us or something like that. But before that also, if there were fiefdoms, so in the fiefdom also were people actually free enough or felt free enough to take their own decisions. I'm just trying to go into the mindset part of it, because if we are today saying that we are going to change the whole mindset and get a culture of mediation in, so we have to go much backward in time to see where that happened. So that way, to a great extent, obviously the schools is an area where definitely a lot of work should happen. But if the people who are going to facilitate the whole thing, the teachers, the principal, and all those, the administration, if they are going to facilitate it, they themselves have to have a different mindset. But if that is not there, that the children will imbibe. So we have I mean, it's not as simple as it seems. It is actually
Uh,
a
I fully
whole
agree with
different
you.
atmosphere. We don't,
I
it's not.
fully agree with you, Vikram. See, Vikram, we have reached this far talking of mediation. How long did this take? 10, 15 years.
But consider that if a point is that whatever we've discussed, even in say India, we talk about the first center in 2005, is all court related. We are
It's all
still talking.
correlated. Yeah,
We are
that's the
still
point.
we are still talking about the chief justice, the courts, the lok adalat happening in
Yes,
the
yes,
courts.
yes, yes.
I am saying.
Pathetically, pathetically.
So what I'm saying is that the people will still associate mediation with courts, and of course mediation with free. This
See,
is the
if Vikram, let us understand this very clearly. If you and I can agree, yes, this system will work, this mediation will work, we can talk things out. You must always remember in village communities, to the best of my knowledge, and in the communities where I have come across, when I talk about all these factors, the first thing I always say is there is nothing which cannot be talked about.
no.
You
What I'm trying
talk
to
it out.
No, but the point is, what I'm trying to say is that we are still hanging on to this whole colonial legacy of, in some way, the courts have a role to play. The courts are,
That's
look,
exactly
they
what
have
I
a,
was trying to
there
point
is,
out.
what I'm trying to say is that there is a building, there is a wall. But you want to go into that wall. I keep saying now that the court should, in India, should put a warning outside that we deny justice, because justice delayed is justice denied. So they should put a warning outside. If you walk in here, justice will be denied to you. But in what we are doing is that the fact that that's an inefficient institution, it is still could not, is not being able to do what they're supposed to do, is now connecting their whole process with mediation in some way, which is not at all connected. I mean, what is mediation and what is litigation? They're two opposite ends. But if we are going to continue, because how has it served this purpose? If in 2005 to today in India, I'm talking about, we are still talking, we've got the word out there, but even today, private mediation is nowhere. Nowhere.
Exactly.
How
See,
many
I'll tell you
people?
how.
No,
I'll
and
tell you how.
further, I'm going into the fact that how many people in this country or anywhere in the world are still able to say that we are only mediators and we do nothing else? How many people can say that? I can, but how many people can say it otherwise?
No, for this reason. It is for this reason. Because it does not reach, see, as from the beginning, I've been repeating, my whole basis is this, Vikram. Mediation should be taken out of alternate dispute resolution mechanism. It is never the mediation is the primary system of a dispute resolution mechanism. Once you drive home that point to the people, this is your primary method. This is your primary method of resolution of a problem.
Yeah. So in that case,
Don't
then yeah, arbitration and litigation should become the alternative.
alternate resolution mechanism.
Definitely, but I'm saying that
Once you start looking at it from that point of view, then we will try to work out. We have to, because we are still evolving as to how to take this to the villages, how to take this to the communities. Taking it to the urban community, housing societies, schools and colleges. Yeah, now law colleges, yes, it has not been made easy because it has been brought into the curriculum.
no, but again, even today we are saying law colleges. The point is the whole culture has to start in every school and every college. We're still connecting into the legal system where we are still saying that it is
It's
part of
because
a social activity.
I'll tell you why. Because as lawyers, we understand how the system has failed. See, first of all, the basic thing is we understand how the adversarial system has failed. Therefore, we can boldly go and say, come on here, look, this is an alternate method available, which is much easier, away from your rules, away from the rules of evidence, away from all this. You have your vent, you give vent to your emotions. Okay, then what is your interest? See, there are so many things which we can do because we are the ones who know where we have failed.
Yep. No, but I'm still saying what I'm saying is that every school, every college, yes, you have to bring this out to them. Definitely, everyone. It's not just law students. That's one part of it. But the point is that even say in the US, I keep talking about it, whatever other sessions we have, is the fact that we keep saying that the US 40 years, and you said that Justice Ahmadi getting something, getting the US, some people from the US involved and everything. We keep looking at that. What is happening in the US is 40 years. Today also 100 million cases are filed in the courts every year. They have a population of only 300 million. So where is the culture of mediation which has developed? The point is, it is still the litigation is still the primary method, and it seems to be the only method because the route goes from there. The thing is that I'm saying that we have to look at a different model if we have to develop a culture of mediation. And what you said, I'll tell you what this whole how I'm looking at it in the terms of the village is that there are already people in the villages who are doing the mediation. They are there.
Yeah,
So this is far removed from the panchayat. The panchayat is a totally different body. There are individuals there. So we have to basically identify those individuals and then bring them out as people who are going to take it up as a profession. People have to value it. Today
I will
also,
give you one example, Vikram. You see, uh, everybody today says that Tamil Nadu Madras High Court was the first court to set up its mediation and conciliation center. Excuse me for saying courts and lawyers again. But actually, in Tamil Nadu, the first step towards mediation was taken by a legal professional, one Dr. Sampath, one Mr. Sampath, A.K. Sampath. He was a roaring practitioner having his practice in Chengalpattu district. Then one fine morning, he gave up the entire practice, stopped, set up an office at Tirupur. Tirupur is a temple town closer to the city of, closer to Mahabalipuram temple. In Tirupur, he set up a small office where he used to write postcards. Whenever a client comes to him, he used to write a postcard to the other side saying, so and so person has come. Here's this grievance. Please come. We will talk. Postcard goes. He was the one who started this mediation practice as such individually. And later on, he published a book known as Tirupuru Papers. If you ever get a chance, you can study that. It's available in the Bangalore National Law School, I think, library. And Madhav Menon, when he was the Vice Chancellor of Bangalore National University, when he opened it, he made him as a faculty member there on mediation. What I'm now trying to tell you is there are plenty of individuals who are still doing this mediation in the villages of whom we have no idea about.
Exactly. That's what I'm saying. That we are
So,
going to identify them,
unless and
and
until, unless and
because
until we expand the horizon, one. Secondly, Vikram, one another point which I would like to highlight here is what is the mediation we are talking of today? We are talking about mediation as was conceived by Yale University and Harvard University and all those people. So it's a package product coming back to us. See, the package of mediation which we are now dealing with is a package product. Why don't why not you consider this aspect of it? Why not you design and develop a mediation process incorporating all the elements of a mediation process
but
indigenous to that of a
Gunaseelan,
local
look,
community?
Gunaseelan, what I'm trying to say is that people sitting somewhere else should devise or whatever we keep saying that the courts and this and everything. There seems to be people sitting somewhere else
Yes,
wanting to, in some way, think how other people should resolve their disputes.
yes.
What while I am saying that that aspect is already happening, the people who are doing it, they are the ones who have to be brought forward. The example that you gave of this person who in Tamil Nadu had started this and those postcard thing and all. The point is that there is a very
Sampath, please remember, Sampath is the father of mediation in
no,
Chennai.
what I'm trying to say, I'll tell you what exactly what I'm trying to say is that if you actually there was a very senior mediator in India who in a webinar recently he said that in their city they actually started a mediation center, private one, and it was doing very well. So these lawyers had got together and they'd done it very well. And what happens is the court starts a mediation center there and they had to close down the mediation center. So what I'm saying is what Mr. Sampath was trying to do could have grown into a movement. That was the way that, look, there is obviously the fact that lawyers have to also, they have to understand this is a noble profession. They had to practice it in a certain way that they went wrong somewhere and not to blame them because we as a society became materialistic. And
I would, Vikram, blame the institutions that are now propagating mediation for this.
blame, they should not be part of
I'll
it.
tell
They
you
should.
why. I'll tell you why. Because barring a few institutions, because I'll definitely exclude this community mediation. The concept of community mediation was first spoken to by Venkatachalaya in their meeting, in their institution. This community mediation is a very good concept, but why it is still not taking off? Why it is still not the 2008, 2010? Yes, now we are in 2021. I have started this community mediation process about talking to educational institutions because thanks to pandemic it put a break, but also gave me a lot of time to pause and read and work more on how we can take this forward. See, there is no point in saying that people are like this. Very difficult to make them understand this. Times are changing, technology is changing. All said and done, people are same. People are people.
Gulasena, what you're saying is the IIAM has come out with a Peacegate app. They're trying to promote community mediation. But where has it reached? Because this is quite some time that they've done it. What have they done? What is happening? I think maybe we should also, maybe you because you're
Exactly.
part of that in some
We
way,
have to.
maybe you can bring something out from there as to what has happened in that whole activity. Because as I saw it from their website, I felt it was quite a good activity. I mean, the way they were
It
trying to
is.
do
It
it.
is. You see, the problem is this, Vikram. Today you talk. That's exactly what I'm saying. See, this 40 hours training program or 60 hours training program or 80 hours training program, 90 hours training program. Don't get the idea that once you get that, you are qualified to be a mediator and
That
start go private.
that is where
That's total nonsense. No, it can't be. You have to practice mediation to do that. So, but once you get this idea, we implemented it. We implemented it through, but one reputed legal institution here. And it was a huge success. 40 students were trained and many were very much interested. Point is this, Vikram, all those people today who speak about mediation in your forum or elsewhere are passionate about mediation. But beyond them, are they able to get in more passionate people?
This is what am I doing? Gunaseelan, if you heard me whenever I talk about it, I'm saying
Out of
I'm trying to get look.
out of every 100 you out of every 100 you interact, you land up with 4, you sustain with 2, you finally land up with one person who can carry forward the torch.
No, which is what I'm saying. My whole movement is that I bring together 1,000 people who have that passion, who will take it forward, and they bring in 1,000. Then we have 1,000,000 people out there who are out there and not just promoting it,
I'm not
actually
saying
getting people.
your calculations looks very bright as a company's balance sheet looks on paper.
No, what do you mean? You are part of that. You are
I'm part
what
of it.
you
I'm
are
part of it,
support.
definitely.
I will keep asking you that what are you doing about it
Second, naturally.
because
See, we are evolving. I'm telling you, I'm evolving.
see,
And the process which
no,
I'm
but gonna say you have a role to play. You have a role to play. The perform. Everyone doesn't have to do the same thing. You have a role
yeah,
to
but
play.
we
No,
in our own
no,
way
no. What
do
I'm saying
things.
is, no. What I'm saying is that you picked up a very good point about the new law which is being drafted. You have a role to play to create that with the policy makers that don't try to regulate something which is actually from its own end something which is party driven. Everything is party driven. Why are you wanting to get into it? Look at the judicial system. Look at your civil procedure code. Look at how that is. I'm going to try to reform that rather than get into an area where nothing requires. We have a very good law. Although you mentioned conciliation, I'll tell you what, the background is that conciliation came into this country because the UNCITRAL was using the word conciliation. They have
Yes,
clarified today, they've today clarified in the 2018 model law
yes,
that
it is not so.
conciliation and mediation is the same thing. There is no difference between the two. Even the definition, in the definition also they put it that
Yes,
whatever name it can be called, because a lot of people were creating this confusion about the whole concept of mediation, conciliation. We don't have a law on mediation. We have the best law in the world. Best law. You can't ask for anything better. But we want to in some way you change the word to mediation. If UNCITRAL is using the word mediation, use it. But the only thing is that the Singapore Convention might be only on international commercial mediation. But when you are putting out you change the word in your conciliation, the part in the law, you put it for everything. It's not only limited to commercial mediation. It can be done for anything.
anything, any mediation.
So we've got a very good law and everything is in place. It's just that we are still trying to, in some way, involve the judiciary because we can't give up this whole colonial aspect. That how can we take the decision? How are we going to be doing anything? This has
See,
been someone
everybody
else.
is passing the buck, Vikram.
Yeah.
The courts are passing the buck to the legislature. The legislature is passing the buck to the court. And in the whole process, we don't have anything definitive.
But
So we take upon ourselves to take as far as possible this message that come on, we can talk things out and solve your problem. Come on, let us resolve.
so that's why I'm saying that
Let
the
us
whole
resolve.
culture of it, that means a lot of work has to be done
A
there.
lot of work has to be done.
That if the people, if the culture is nowhere there, we don't have to be developed. But only I'm surprised that Giovanni has no question to ask. Giovanni, the nothing for Gunaseelan. If you can put your virtual hand up if you want to ask him something. But there were a lot of other things that you have spoken about which definitely I think we needs a lot of discussion on because of definitely what you're saying in terms of residential areas and all that will have to be put in place. The only thing, like I keep saying, is that it's not about just telling them about something which they're not even aware of. It's a process. They're not doing it.
Yes.
So the down to the children and everything.
From my point of view, Vikram, I'll tell you. I think 2018 I started it. This taking it to the groups and taking it to the villages, taking it to the colleges. And I've spoken with quite a lot of people, quite a lot of people with authority who can make the changes. But you see, the pandemic is a big drawback. Is actually a big drawback. Secondly, yes, virtual conferences, virtual meetings can help to an extent. But when you speak of core values of a systemic transformation in a society, where your perception of resolving a dispute or finding a solution to a dispute or living with a solution, these are all aspects which you can't just like that do it in a virtual platform. You have to meet them, you have to communicate with them, and this is a laborious process. I'm on the way. I have a long way to go, a long road to travel. Yeah, probably I'll be shortly writing a small paper on my experiences and what need to be done and what should be done and all that. But let us see. But I'm not giving up.
Yep, absolutely,
See,
absolutely.
I'm 66, but I'm what do you call? I would say I'm 40 years younger, so I can still
No,
do.
no, no, it'll all happen. Basically, good intentions are required. Everything happens around that.
Yeah,
So what
we
I'll do is
can.
let me just end the session here,
Yeah.
and then obviously if you have something we can discuss it. Thank you very much. Excellent. Obviously, discussing things with you is always nice, and lots of work to be done. And I think you're on the right track.